The morning mist hung thick over Buckingham Palace as Lord Justice Sir Edmund Worthington adjusted his ancient ceremonial robes. At 72, he had served the crown for nearly 5 decades, but today would mark the most controversial moment of his distinguished career. His weathered hands trembled slightly as he reviewed the leather-bound documents that would soon shake the very foundations of the British monarchy. The grand courtroom within Westminster Palace buzzed with unprecedented tension. Journalists from around the world had gathered, their cameras and microphones ready to capture what many believed would be nothing more than a formal procedural hearing. They had no idea they were about to witness a legal earthquake that would reverberate through royal circles for generations to come. Sir Edmund's assistant, a nervous young woman named Margaret, approached his bench with obvious anxiety. "My lord," she whispered, "the royal representatives have arrived. They're requesting a private audience before the proceedings begin." Her voice carried the weight of understanding that something extraordinary was about to unfold. The distinguished judge shook his head firmly. "No private audiences today, Margaret. Justice must be served in the full light of public scrutiny." His steel-gray eyes reflected decades of unwavering commitment to legal principles, even when those principles might challenge the most powerful institution in the realm. Across the courtroom, a small group of constitutional lawyers huddled together, their faces grave with concern. They had spent months researching ancient laws and forgotten statutes, uncovering what they believed to be a fundamental flaw in the recent royal proclamation that had elevated Camilla to queen consort. Their findings, if proven correct, would invalidate her title and create a constitutional crisis unlike anything Britain had seen in centuries. The lead barrister, Helena Morrison QC, was a formidable woman in her 50s who had built her reputation on challenging established authority. She had initially dismissed the case as frivolous until her team discovered a series of medieval laws that had never been formally repealed. These ancient statutes contained specific requirements for royal marriages and title conferrals that appeared to have been overlooked in the modern era. As the clock approached 10 o'clock, the heavy oak doors of the courtroom swung open. A procession of royal officials entered, their faces masks of controlled concern. They had expected this hearing to be a brief formality, easily dismissed by a judge who understood the delicate balance between law and tradition. None of them had anticipated that Sir Edmund Worthington would prove to be a man who valued legal precedent above royal convenience. The atmosphere grew electric as Sir Edmund took his position behind the imposing judicial bench. His presence commanded immediate respect and silence from the packed courtroom. Every person present understood they were witnessing a moment that would be remembered and analyzed by historians for decades to come. "Ladies and gentlemen," Sir Edmund began, his voice carrying clearly through the vast chamber, "we are gathered today to examine a matter of profound constitutional significance. The petitioners have raised questions regarding the legal validity of certain recent royal proclamations, specifically those concerning titles and succession rights." A murmur rippled through the assembled crowd. The royal representatives shifted uncomfortably in their seats, clearly unprepared for the formal gravity with which the judge was treating their perceived routine hearing. They had come expecting a quick dismissal, not a full legal examination of their most cherished traditions. Helena Morrison rose from her position, her black robes billowing dramatically as she prepared to present her case. In her hands, she carried copies of documents that had been gathering dust in parliamentary archives for centuries. These papers, she believed, contained the legal ammunition necessary to challenge the very foundations of the current royal structure. "Your Lordship," she began, her voice steady despite the magnitude of her task, "my clients have uncovered evidence that suggests fundamental procedural errors in the recent elevation of Queen Camilla to her current position. We intend to demonstrate that ancient laws, still technically in force, were not properly observed during the title conferral process." The royal legal team, led by Sir Reginald Blackstone, the Crown's most senior barrister, immediately objected. "My lord, with the greatest respect, we submit that this entire proceeding is without merit. The Crown's prerogative in matters of royal titles has been established through centuries of precedent and cannot be challenged in this manner." Sir Edmund raised his hand for silence, his expression revealing nothing of his thoughts. "Sir Reginald, while I appreciate the Crown's position, this court has a duty to examine any properly presented legal challenge, regardless of its target. The law applies equally to all subjects of the realm, and that principle extends even to our most revered institutions. The judge's words sent shockwaves through the royal delegation. They had never imagined that a British court would seriously consider challenging royal prerogatives. The concept seemed almost treasonous, yet here was one of the country's most respected jurists treating the matter with complete seriousness. Margaret, the court assistant, noticed several royal officials whispering urgently among themselves. Mobile phones were being discreetly used, undoubtedly to alert higher authorities about the unexpected turn of events. The palace had clearly not anticipated this level of legal scrutiny and was scrambling to respond appropriately. As the morning progressed, it became increasingly clear that Sir Edmund intended to conduct a thorough examination of every legal argument presented. His questions were penetrating and demonstrated a comprehensive understanding of constitutional law that impressed even the most experienced barristers present. The packed gallery included members of Parliament, legal scholars, and representatives from various Commonwealth nations who would be significantly affected by any ruling that questioned the validity of royal titles. The implications extended far beyond Britain's borders, potentially affecting the entire structure of the modern Commonwealth. Helena Morrison presented her opening arguments with methodical precision, outlining how her research had uncovered specific procedural requirements that appeared to have been overlooked. She spoke of ancient ceremonies, forgotten oaths, and legal formalities that had been deemed obsolete, but had never been formally abolished by Parliament. The tension in the courtroom was palpable as she concluded her opening statement. "Your Lordship, we do not challenge these proceedings lightly. However, the law must be supreme, even when its application proves inconvenient to established power structures. If these ancient statutes remain valid, then the recent title conferral may indeed be legally invalid." Sir Edmund nodded gravely, fully aware that his next words would determine whether this case would proceed to a full hearing or be dismissed as constitutional overreach. The entire future of the British monarchy might hang in the balance of his decision. The second day of proceedings began with an air of heightened security around Westminster Palace. Overnight, news of the unprecedented legal challenge had spread across global media, creating a sensation that threatened to overshadow even the most dramatic royal scandals of recent decades. Protesters and supporters had gathered outside the courthouse, their chants creating a backdrop of public opinion that seemed almost evenly divided. Inside the courtroom, Sir Edmund Worthington appeared more resolute than ever. His research team had worked through the night, examining every precedent and statute that might bear on the case. The judge understood that his decision would not only affect the immediate parties but would establish legal principles that could reshape the relationship between the monarchy and the law for generations to come. Helena Morrison, QC, had spent the evening preparing her most crucial evidence. Ancient documents, some dating back to the 14th century, lay carefully arranged before her. These yellowed parchments contained laws written in archaic language that nevertheless carried the full force of parliamentary authority. Her translation experts had worked meticulously to ensure that every word was properly interpreted and presented. The royal legal team had been reinforced overnight with additional constitutional experts flown in from Scotland and Northern Ireland. Sir Reginald Blackstone now led a formidable group of barristers who had devoted their careers to protecting royal prerogatives. They understood that failure in this case could open the floodgates to countless future challenges against the crown. As proceedings resumed, Helena Morrison rose to present her most damaging evidence. "Your Lordship, I direct your attention to the Statute of Royal Matrimony, enacted in 1351 and never formally repealed by any subsequent parliament. This law establishes specific requirements for the recognition of royal spouses and their subsequent elevation to positions of equal rank." She held up a carefully preserved document, its medieval script barely legible to modern eyes. "The statute requires that any person marrying into the royal family must undergo a ceremonial validation before a council of senior clergy and nobles. This validation must occur within 1 calendar year of the marriage ceremony, or the union cannot confer royal status upon the non-royal spouse." A gasp rippled through the courtroom as the implications became clear. Queen Camilla's marriage to the then Prince Charles had taken place years ago, but no such ceremonial validation had ever been performed. If Helena's interpretation was correct, Camilla's current title as Queen Consort might indeed be legally invalid. Sir Reginald immediately stood to object. "My lord, this interpretation is both anachronistic and impractical. The statute in question was clearly intended for the medieval period and has been superseded by centuries of evolving constitutional practice. The Crown's position is that such ancient laws cannot be applied to modern circumstances without parliamentary approval." Sir Edmund studied the document carefully, his expression revealing the weight of the decision before him. "Sir Reginald, while I understand your position, the law is quite clear that statutes remain in force until they are explicitly repealed or superseded. Parliament has had numerous opportunities over the centuries to address these ancient laws, yet they remain on the books." The judge's words sent shockwaves through the royal delegation. Several officials were seen making urgent phone calls during the brief recess that followed. The palace was clearly scrambling to understand the full implications of these long-forgotten legal requirements. During the break, Margaret approached Sir Edmund with obvious concern. "My lord, I've received several calls from government officials requesting immediate consultation. The Prime Minister's office is particularly insistent on speaking with you before proceedings continue." Sir Edmund's response was firm and uncompromising. "Margaret, please inform all government officials that this court operates independently of political pressure. The law will be applied without fear or favor, regardless of the consequences for any particular institution or individual." When proceedings resumed, Helena Morrison continued her methodical presentation of evidence. She had discovered that similar ceremonial validations had been performed for other royal marriages throughout history, establishing a clear precedent for the requirement. Royal weddings in the 15th and 16th centuries had routinely included these formal recognition ceremonies, often involving elaborate rituals that confirmed the new spouse's acceptance into the royal bloodline. "Your lordship," Helena continued, "the evidence shows that this requirement was considered so fundamental that it was written into numerous marriage contracts and succession documents. The failure to perform such a ceremony was traditionally grounds for questioning the legitimacy of any children born to such unions. This revelation created an even greater stir in the courtroom. The implications extended beyond Queen Camilla's title to potentially affect the entire line of succession. If her marriage was not properly validated under ancient law, it could theoretically impact the status of any future children and their potential claims to royal titles. Sir Reginald fought back with arguments based on modern constitutional theory. "My lord, the petitioners are essentially asking this court to invalidate centuries of constitutional evolution. The monarchy has adapted and modernized precisely because it has not been bound by every ancient statute. To apply medieval law to contemporary circumstances would create chaos throughout the Commonwealth." The Crown's position was logical and practical, but Sir Edmund seemed more interested in the strict application of legal principle than in political convenience. His questions to both sides revealed a deep understanding of constitutional law and a determination to reach a decision based purely on legal merit rather than practical considerations. As the day progressed, expert witnesses were called to testify about the historical application of ancient statutes. Professor Elizabeth Thornton, a renowned medieval law scholar from Oxford University, provided detailed testimony about the original intent and application of the disputed legislation. Her evidence strongly supported Helena Morrison's interpretation of the ancient requirements. Conversely, Professor James Ashworth from Cambridge presented the Crown's historical perspective, arguing that constitutional practice had evolved to make such ancient requirements obsolete. His testimony emphasized the dangers of rigid adherence to medieval law in a modern, constitutional monarchy. The battle lines were clearly drawn between strict legal interpretation and practical, constitutional evolution. Sir Edmund's questions revealed his struggle to balance respect for ancient law with the realities of modern governance. Every person in the courtroom understood that his decision would establish precedents affecting not only the current royal family, but future generations of monarchs. As the second day concluded, Sir Edmund announced his intention to review all evidence carefully before proceeding. The gravity of his expression suggested that he fully understood the historical significance of the decision before him. The future of the British monarchy might well depend on how he interpreted centuries-old statutes that few people had even known existed. Outside the courthouse, crowds had grown larger and more vocal. Public opinion seemed divided between those who supported strict adherence to the law and those who viewed the challenge as an attack on cherished institutions. The controversy had awakened deep-seated debates about the role of monarchy in modern society and the relationship between ancient law and contemporary governance. The third day brought unexpected drama as news broke that Buckingham Palace had issued an unprecedented statement regarding the ongoing legal proceedings. The palace, traditionally silent on matters before the courts, had released a carefully worded document acknowledging the seriousness of the legal challenge while maintaining confidence in the validity of all royal titles and positions. Sir Edmund Worthington arrived at court that morning to find his chambers filled with urgent correspondence from legal scholars across the Commonwealth. Universities from Canada to Australia had submitted detailed analyses of how the case might affect their own constitutional arrangements. The scope of potential consequences was becoming clearer with each passing hour. Helena Morrison, QC, had discovered additional evidence during her overnight research. Hidden within the parliamentary archives, she had found records of a secret legal opinion prepared for King Edward VII in 1902, addressing similar questions about ancient marriage statutes. The opinion, written by the then Lord Chancellor, had concluded that the medieval laws remained technically valid and should be observed to avoid future constitutional difficulties. "Your Lordship," Helena announced as proceedings resumed, "this newly discovered document proves that the highest legal authorities of the early 20th century recognized the continuing validity of these ancient statutes. The Crown was specifically advised to ensure compliance with all historical requirements. Yet this advice appears to have been ignored in subsequent royal marriages." The revelation sent shockwaves through the royal legal team. Sir Reginald Blackstone requested an immediate recess to review the new evidence, clearly caught off guard by this development. The document Helena had discovered was authentic and devastating to the Crown's position that ancient laws were no longer applicable. During the recess, frantic phone calls were made between Westminster and Buckingham Palace. Palace officials who had initially viewed the case as a minor irritant now realized they were facing a genuine constitutional crisis. The possibility that Queen Camilla's title might be legally invalid was no longer a theoretical concern but a real and immediate threat. When proceedings resumed, Sir Reginald attempted to minimize the impact of the newly discovered evidence. "My lord, while this historical document is certainly interesting, it represents the opinion of one man in a different era. Constitutional law has evolved significantly since 1902, and we submit that modern practice has superseded these ancient requirements." However, Sir Edmund appeared skeptical of this argument. "Sir Reginald, if the highest legal authority of the realm advised compliance with these statutes in 1902, on what basis do you argue that they have since become invalid? Has any subsequent parliament explicitly repealed these laws?" The Crown's lawyer was forced to admit that no formal repeal had ever taken place. The medieval statutes remained technically in force, creating a legal minefield that the royal family had unknowingly entered. The silence in the courtroom was deafening as the implications sank in. Professor Margaret Sinclair, a constitutional expert from Edinburgh University, was called as a witness to explain the technical aspects of royal title conferral. Her testimony revealed that the process of creating royal titles had indeed followed established patterns throughout history, with specific ceremonies and validations required for different types of positions. "The historical record is quite clear," Professor Sinclair explained. "Royal spouses who were elevated to positions of equal rank underwent formal recognition ceremonies that were considered essential for legal validity. These ceremonies weren't merely traditional celebrations, but carried genuine legal significance under the statutes then in force." Her testimony was particularly damaging because it established that the royal family itself had historically recognized the importance of these ceremonial requirements. The Crown could not easily dismiss as obsolete procedures that their own ancestors had considered legally necessary. Helena Morrison pressed her advantage by presenting evidence of similar ceremonies performed for other European royal families. Even in recent decades, some monarchies had maintained versions of these ancient rituals, recognizing their continued legal significance. The British royal family appeared to be unique in having abandoned these requirements entirely. The afternoon session brought testimony from Dr. William Hastings, a genealogist specializing in royal succession. His evidence revealed that questions about the validity of royal marriages had arisen repeatedly throughout history, often with serious consequences for inheritance and succession rights. Several potential heirs had been excluded from the line of succession specifically because their parents' marriages had not met all legal requirements. The precedents are clear, Dr. Hastings testified. Failure to comply with ceremonial requirements has historically been grounds for questioning the validity of royal titles and positions. The law has consistently held that all requirements must be met, regardless of their apparent antiquity or inconvenience. This testimony hit the royal delegation like a thunderbolt. The possibility that Queen Camilla's title might be invalid was serious enough, but the implications for future succession were even more troubling. If the court ruled that the ancient statutes were still valid, it could open questions about other royal marriages and their compliance with forgotten legal requirements. Sir Edmund's questions during cross-examination revealed his deep concern about the broader implications of the case. Dr. Hastings, in your opinion, what would be the practical effect if this court were to rule that these ancient statutes remain legally binding? The genealogist's response was sobering. My lord, such a ruling would require a complete review of all royal marriages and title conferral since the medieval period. Any ceremonies that failed to meet the ancient requirements might be subject to legal challenge, potentially affecting numerous members of the current royal family. The courtroom erupted in murmurs as the full scope of the crisis became apparent. This was no longer simply about Queen Camilla's title, but about the legal foundation of the entire modern royal family structure. Centuries of constitutional evolution might be called into question by the strict application of forgotten medieval law. As the day concluded, Sir Edmund announced that he would need additional time to consider the complex legal and constitutional issues raised by the evidence. His expression suggested that he was struggling with the enormous responsibility of making a decision that could reshape British constitutional law. Outside the courthouse, the crowds had grown even larger. News of the secret legal opinion from 1902 had leaked to the media, creating a sensation that dominated headlines around the world. Royal watchers and constitutional experts were debating the implications on every news channel and social media platform. The palace remained officially silent, but sources close to the royal family suggested that urgent consultations were taking place with the government. The Prime Minister was reportedly considering whether emergency legislation might be necessary to resolve the constitutional crisis, though such action would itself raise serious questions about parliamentary interference with judicial proceedings. As night fell over Westminster, everyone involved in the case understood that they were witnessing a potential turning point in British constitutional history. The ancient statutes that had lain dormant for centuries were suddenly at the center of a legal storm that threatened to engulf the monarchy itself. The fourth day of proceedings began with unprecedented security measures around Westminster Palace. Overnight, the government had reportedly held emergency meetings to discuss the constitutional implications of the case. Rumors circulated that senior ministers were considering various options, including potential emergency legislation, though such intervention would raise serious questions about judicial independence. Sir Edmund Worthington arrived at court that morning to find his chambers under heavy guard. Death threats and angry letters had poured in from both supporters and opponents of the legal challenge. The judge's determination to apply the law without regard to political consequences had earned him both admiration and condemnation from different segments of society. The royal legal team had been further reinforced overnight with the addition of Sir Geoffrey Pemberton, the Crown's most senior constitutional advisor. His presence signaled that the palace was now treating the case as a genuine existential threat, rather than a minor legal irritant. The stakes had risen dramatically as the implications of the ancient statutes became clearer. Helena Morrison QC began the day by presenting her most dramatic piece of evidence yet. Her research team had discovered records of a secret ceremony performed in 1796 for Princess Caroline of Brunswick, the controversial wife of the future King George IV. The ceremony, conducted according to the ancient statutes, had been specifically designed to validate her royal status despite widespread opposition to the marriage. "Your Lordship," Helena announced, This evidence proves that the royal family themselves recognized the continuing validity of these ancient requirements well into the modern era. Princess Caroline's ceremony was performed precisely because legal advisors understood that the medieval statutes remained in force and required compliance, and the discovery was devastating to the Crown's position. Sir Geoffrey Pemberton immediately rose to object, but his argument seemed increasingly desperate as the historical evidence mounted against him. The royal family's own actions in previous centuries had established clear precedents for the very procedures they now claimed were obsolete. During the morning recess, Margaret informed Sir Edmund that several Commonwealth governments had formally requested updates on the proceedings. Canada, Australia, and New Zealand were particularly concerned about how any ruling might affect their own constitutional arrangements with the Crown. The case was no longer a purely British matter but had international implications. Professor David Richardson, a leading expert on medieval English law from Cambridge University, was called to provide expert testimony on the original intent of the disputed statutes. His evidence revealed that the ceremonial requirements had been considered so fundamental that failure to comply was traditionally treated as grounds for annulling royal marriages entirely. The medieval legislators understood that royal marriages were not merely personal matters but constitutional events with profound implications for the realm. Professor Richardson explained, the ceremonial requirements were designed to ensure that such unions received proper validation from the highest authorities in church and state. His testimony established that the ancient statutes were not merely technical requirements but represented fundamental constitutional principles about the nature of royal authority and legitimacy. The failure to comply with these requirements was not a minor oversight but a serious breach of constitutional law that had historically carried severe consequences. Where Geoffrey Pemberton attempted to undermine this testimony by arguing that constitutional practice had evolved beyond the need for such ancient ceremonies. My lord, the Crown submits that centuries of peaceful succession and public acceptance have superseded these medieval requirements. The monarchy's legitimacy derives from popular consent and parliamentary recognition, not from ancient rituals. However, Sir Edmund appeared unconvinced by this argument. Sir Geoffrey, while popular acceptance is certainly important, this court must determine whether the law has been properly followed. If Parliament intended to supersede these ancient statutes, why has it never formally repealed them? The Crown's lawyer struggled to provide a satisfactory answer. The truth was that the ancient statutes had been forgotten rather than deliberately superseded, creating a legal vacuum that had now been exposed by Helena Morrison's meticulous research. The afternoon session brought testimony from Archbishop Theodore Whitfield, one of the Church of England's most senior figures. His evidence revealed that the Church had historically played a crucial role in the ceremonial validation of royal marriages, with specific prayers and blessings required under the ancient statutes. The spiritual dimension of these ceremonies was considered essential, Archbishop Whitfield explained. Royal marriage was understood to be not merely a civil contract, but a sacred covenant that required divine blessing and ecclesiastical validation. The failure to perform these ceremonies would have been considered spiritually as well as legally deficient. This testimony added another layer of complexity to the case. If the ancient statutes required specific religious ceremonies, then Queen Camilla's elevation might be invalid not only under civil law, but also under canon law. The implications for the monarchy's relationship with the established church were potentially serious. Helena Morrison seized upon this testimony to strengthen her case. Your Lordship, the evidence clearly shows that the ceremonial requirements were not merely traditional formalities, but carried genuine legal and spiritual significance. The Crown's failure to comply with these requirements cannot be dismissed as a minor technicality. As the day progressed, it became increasingly clear that Sir Edmund was taking the legal challenge seriously. His questions revealed a deep understanding of the complex constitutional issues involved and a determination to reach a decision based purely on legal principle rather than political convenience. The judge's most significant intervention came during the afternoon session when he questioned Sir Geoffrey Pemberton directly about the Crown's legal strategy. Sir Geoffrey, if this court were to rule that the ancient statutes remain valid, what would be the Crown's position regarding compliance with their requirements? The question sent shockwaves through the royal delegation. Sir Edmund was clearly considering the possibility of ruling in favor of the petitioners, and he wanted to understand what remedies might be available if he did so. Sir Geoffrey's response was carefully measured. "My lord, the Crown maintains that such a ruling would be inappropriate and potentially unconstitutional. However, if the court were to reach such a conclusion, we would naturally consider all available options for compliance while seeking appropriate legal remedies." The diplomatic language could not disguise the crisis that such a ruling would create. The royal family would face the unprecedented choice of either complying with ancient ceremonial requirements or challenging the court's authority through appeals or emergency legislation. As the fourth day concluded, Sir Edmund announced that he would hear final arguments the following day before retiring to consider his verdict. His expression suggested that he was fully aware of the historical significance of the decision he faced. The future relationship between law and monarchy in Britain might well depend on his interpretation of centuries-old statutes. Outside the courthouse, the crowds had become increasingly vocal and polarized. Supporters of the legal challenge argued that no institution should be above the law, while defenders of the monarchy warned that the case threatened to destroy centuries of constitutional stability. The division in public opinion reflected the profound questions about law, tradition, and authority that the case had raised. The media coverage had reached fever pitch, with constitutional experts debating the implications on every platform. Some argued that the case represented a necessary assertion of legal principle, while others warned that rigid adherence to ancient law could undermine the flexible constitutional arrangements that had served Britain well for centuries. As night fell over Westminster, everyone involved understood that they were witnessing a potential watershed moment in British constitutional history. The ancient statutes that had been forgotten for so long were about to determine the fate of the modern monarchy. The fifth day arrived with London gripped by constitutional fever. Overnight, leaked reports suggested that Buckingham Palace had held emergency meetings lasting until dawn, with senior royals and government ministers attempting to devise strategies for dealing with a potential adverse ruling. The Prime Minister had reportedly cancelled all other appointments to focus exclusively on the developing crisis. Sir Edmund Worthington entered the courthouse that morning knowing that his decision would reverberate through history. The weight of responsibility was evident in his measured steps and grave expression. Legal scholars would analyze every word of his ruling for decades to come, and the precedent he established would affect the relationship between law and monarchy for generations. Helena Morrison QC prepared to deliver her final arguments with a mixture of excitement and trepidation. Her research had uncovered legal principles that had been dormant for centuries, but she understood that victory in this case would fundamentally alter the British constitutional landscape. The implications extended far beyond Queen Camilla's title to encompass the entire structure of royal authority. The courtroom was packed to capacity with international observers, constitutional experts, and media representatives from around the world. The security presence had been increased dramatically after overnight threats against both the judge and the legal teams. The atmosphere was electric with tension, as everyone understood they were witnessing a potential turning point in British legal history. Sir Geoffrey Pemberton rose to present the Crown's final arguments, his demeanor reflecting the enormous pressure the royal legal team was under. "My lord, the Crown submits that this court must consider not merely the letter of ancient law but the spirit of constitutional evolution. To apply medieval statutes to modern circumstances would create chaos throughout the constitutional system." His argument was compelling and practical, emphasizing the dangers of rigid adherence to ancient law in a modern democracy. The Crown's position was that constitutional arrangements had evolved organically over centuries, with ancient requirements being superseded by newer practices and understandings. However, Helena Morrison's response was devastating in its simplicity. "Your Lordship, the Crown's argument essentially asks this court to ignore the law because compliance would be inconvenient. But if we accept that principle, what prevents any institution from claiming exemption from legal requirements that it finds burdensome?" Her words struck at the heart of the rule of law itself. If the monarchy could ignore ancient statutes simply because they were old or inconvenient, then the principle that law applies equally to all would be fatally undermined. The implications extended far beyond the immediate case to encompass fundamental questions about legal authority, and institutional accountability. Sir Edmund's questions during the final arguments revealed the depth of his struggle with the constitutional implications. Ms. Morrison, if this court were to rule in your favor, what specific remedies would you seek? Are you asking this court to declare Queen Camilla's title invalid? The question hung in the air like a thunderclap. Helena's response was careful but uncompromising. My lord, we seek a declaration that the ancient statutes remain valid and must be complied with. The specific implications for any individual titles would flow naturally from that legal determination. The diplomatic language could not disguise the revolutionary nature of her request. If Sir Edmund ruled that the ancient statutes were still valid, it would effectively invalidate Queen Camilla's title unless she underwent the ceremonial validation required by medieval law. The unprecedented nature of such a ruling sent shockwaves through the royal delegation. During the brief recess that followed, urgent phone calls were made between the courthouse and various government departments. The Cabinet Office had reportedly prepared contingency plans for different scenarios, including the possibility of emergency parliamentary sessions and even constitutional amendments. When proceedings resumed, Sir Geoffrey made one final desperate argument. My lord, the Crown respectfully submits that this court lacks jurisdiction to rule on matters of royal prerogative. The conferral of royal titles has traditionally been considered beyond the scope of judicial review. Sir Edmund's response was swift and decisive. Sir Geoffrey, while I respect the Crown's position, this court has jurisdiction to interpret and apply the law of the land. If Parliament has established statutory requirements for royal marriages and title conferrals, then this court has both the authority and the duty to determine whether those requirements have been met. The judge's words effectively demolished the Crown's final line of defense. The royal prerogative, while extensive, could not override specific statutory requirements enacted by Parliament. The ancient statutes, however old and forgotten, carried the full force of parliamentary authority. As the final arguments concluded, Sir Edmund announced that he would retire to consider his verdict. The gravity in his voice suggested that he fully understood the historical significance of the decision he faced. Ladies and gentlemen, this case raises profound questions about the relationship between law and tradition in our constitutional system. I will give these matters the careful consideration they deserve. The courtroom emptied slowly, with observers understanding that they might have just witnessed the end of an era in British constitutional history. The ruling, when it came, would either reaffirm the supremacy of law over tradition or establish new principles about constitutional evolution and practical governance. Outside the courthouse, the crowds had reached unprecedented size. Police barriers strained under the pressure of thousands of people who had gathered to witness this historic moment. Public opinion remained sharply divided, with passionate arguments on both sides about the proper balance between legal principle and constitutional stability. The international implications were becoming clearer by the hour. Commonwealth governments had placed their own constitutional experts on standby, ready to respond to whatever ruling Sir Edmund might deliver. The ripple effects would extend far beyond Britain's shores to affect monarchies and constitutional arrangements around the world. Media coverage had reached saturation point, with every major news organization providing continuous coverage of the proceedings. Constitutional experts offered endless analysis and speculation about the potential outcomes. But everyone understood that Sir Edmund's decision was ultimately unpredictable. In Buckingham Palace, the royal family faced the unprecedented possibility that one of their own might be declared to hold an invalid title. The personal implications for Queen Camilla were devastating enough, but the broader constitutional crisis threatened to undermine the stability that the monarchy had enjoyed for centuries. As evening fell over Westminster, Sir Edmund Worthington worked alone in his chambers, surrounded by centuries of legal precedent and constitutional theory. The decision he reached would determine not only the fate of Queen Camilla's title, but the future relationship between law and monarchy in Britain. The weight of history pressed down upon him as he prepared to render one of the most significant judicial decisions in British legal history. The ancient statutes that had lain dormant for so long were about to speak with the full authority of law, and their voice would echo through the corridors of power for generations to come. 3 days had passed since Sir Edmund Worthington retired to consider his verdict, and the tension throughout Britain had reached breaking point. The palace had maintained complete silence, but sources close to the royal family suggested that contingency plans were being prepared for multiple scenarios. Emergency meetings continued around the clock, involving the highest levels of government and the royal household. The judge had worked tirelessly in his chambers, surrounded by towers of legal documents dating back centuries. His research team had compiled exhaustive analyses of every relevant precedent and constitutional principle. The decision he faced was not merely legal, but profoundly political, with implications that would reshape the British constitutional landscape forever. On the morning of the 6th day, Sir Edmund emerged from his chambers with a thick folder containing his written judgment. His expression revealed nothing of his conclusions, but the gravity in his demeanor suggested that he had reached a decision of enormous significance. The entire legal and political establishment held its breath as he prepared to deliver his ruling. The courtroom had been completely redesigned to accommodate the unprecedented level of international interest. Additional seating had been installed for diplomatic observers, constitutional experts, and media representatives from around the world. Security was tighter than for any previous legal proceeding in British history, with armed guards stationed throughout the building. As Sir Edmund took his position behind the judicial bench, the silence in the courtroom was absolute. Every person present understood that they were about to witness a moment that would be remembered and studied for centuries. The future of the British monarchy hung in the balance of the words he was about to speak. "Ladies and gentlemen," Sir Edmund began, his voice carrying clearly through the packed chamber. "This case has required this court to examine fundamental questions about the relationship between law and tradition in our constitutional system. The petitioners have raised serious questions about compliance with ancient statutes, while the Crown has argued for constitutional evolution and practical governance." He paused, allowing the weight of his words to settle over the assembled crowd. The royal delegation sat rigid with tension, while Helena Morrison leaned forward in anticipation of vindication for her exhaustive research. After careful consideration of all evidence and arguments, Sir Edmund continued, "This court finds that the Statute of Royal Matrimony of 1351, along with its related provisions, remains valid and legally binding. Parliament has never formally repealed these statutes, and they therefore retain the full force of law." A gasp rippled through the courtroom as the implications of his words became clear. Helena Morrison's face lit up with triumph, while the royal legal team appeared stunned by the magnitude of the ruling. Sir Geoffrey Pemberton's carefully composed expression cracked for the first time during the proceedings. "However," Sir Edmund continued, raising his hand for silence, "this court must also consider the practical implications of applying ancient law to modern circumstances. The strict application of these statutes without regard to constitutional evolution would create unacceptable disruption to our established governmental system." The qualification sent another wave of murmurs through the packed gallery. Sir Edmund was clearly attempting to balance legal principle with practical governance, but the direction of his ultimate ruling remained unclear. "Therefore," the judge announced with deliberate gravity, "this court declares that while the ancient statutes remain technically valid, they must be interpreted in light of modern constitutional practice. The ceremonial requirements they establish are legally binding but may be satisfied through contemporary equivalents that serve the same constitutional function." The ruling was both revolutionary and conservative, upholding the supremacy of law while allowing for practical adaptation. Queen Camilla's title was not immediately invalidated, but the Crown was required to ensure compliance with the ancient ceremonial requirements through modern means. Specifically, Sir Edmund continued, "This court orders that a ceremonial validation must be performed within 6 months to satisfy the requirements of the ancient statutes. This ceremony must include the participation of senior church officials and representatives of the nobility, as specified in the original legislation." The courtroom erupted in chaos as the full implications of the ruling became clear. Queen Camilla would be required to undergo a medieval-style validation ceremony, or her title would indeed become legally invalid. The unprecedented nature of the order sent shockwaves through the royal delegation and government officials present. Helena Morrison rose to address the court, her voice trembling with emotion. "Your Lordship, this ruling represents a magnificent vindication of the principle that no institution is above the law. The petitioners are grateful for this court's careful consideration of these vital constitutional issues. Sir Geoffrey Pemberton struggled to maintain his composure as he responded, "My lord, while the Crown respects this court's authority, we must respectfully indicate our intention to appeal this decision to the highest available tribunal. The implications for constitutional governance are too serious to accept without exhaustive review." Sir Edmund nodded gravely. "Sir Geoffrey, the Crown certainly has the right to appeal, and this court would expect no less on a matter of such constitutional significance. However, until any appeal is concluded, this court's order remains in effect." As the judge concluded his formal ruling, the courtroom descended into barely controlled pandemonium. Journalists rushed to file reports while constitutional experts attempted to analyze the implications of this unprecedented decision. The royal delegation huddled together in urgent consultation, clearly struggling to process the magnitude of the crisis they now faced. Outside the courthouse, the crowds erupted in celebrations and protests as news of the ruling spread. Supporters of the legal challenge viewed it as a victory for democratic principle and the rule of law, while defenders of the monarchy saw it as an attack on centuries of constitutional tradition. The international implications were immediate and severe. Commonwealth governments that recognized the British Crown were forced to grapple with questions about the validity of their own constitutional arrangements. If Queen Camilla's title was legally questionable, what did that mean for her role in their governmental systems? Within hours, emergency sessions were called in parliamentary capitals across the Commonwealth. Constitutional experts worked frantically to analyze how Sir Edmund's ruling might affect their own legal systems and relationships with the Crown. In Buckingham Palace, the royal family faced an unprecedented crisis. The prospect of Queen Camilla undergoing a medieval validation ceremony was both practically challenging and potentially humiliating. Yet the alternative of losing her royal title was even more unthinkable. The government's response was swift and dramatic. The Prime Minister announced an emergency parliamentary session to consider legislation that might address the constitutional crisis. However, such intervention would raise serious questions about parliamentary interference with judicial decisions and the separation of powers. As evening fell over Westminster, Sir Edmund Worthington returned to his chambers knowing that his decision had triggered the greatest constitutional crisis in modern British history. The ancient statutes he had validated would now force the monarchy to choose between legal compliance and institutional revolution. The precedent was set, the order was given, and the countdown had begun. Queen Camilla had 6 months to undergo a ceremony that would either validate her position or expose the monarchy to legal challenges that could reshape the entire constitutional system. The forgotten laws of medieval England were about to collide with the realities of modern governance in ways that no one could have anticipated. 6 months had passed since Sir Edmund Worthington's earth-shaking ruling, and Britain had endured the most intense constitutional crisis in its modern history. The appeal process had wound its way through the highest courts in the land, with each tribunal upholding the original decision with minor modifications. The ancient statutes were indeed valid, and the ceremonial validation could not be avoided. Throughout this period, Queen Camilla had maintained a dignified silence, while scholars and ceremonial experts worked to design a validation ceremony that would satisfy both legal requirements and modern sensibilities. The challenge had been enormous, requiring the resurrection of medieval protocols that had been forgotten for centuries while adapting them to contemporary constitutional realities. The chosen venue was Westminster Abbey, the same ancient church where coronations had taken place for nearly 1,000 years. The ceremony would follow closely the patterns established in medieval times, with representatives from the highest ranks of nobility and clergy participating in formal validation of Queen Camilla's royal status. As the day of the ceremony approached, public opinion had gradually shifted in an unexpected direction. What had initially been viewed as a humiliating ordeal for the monarchy had transformed into a celebration of constitutional principle and legal tradition. The royal family's willingness to comply with the court's order had earned widespread respect, even from initial critic Sir Edmund Worthington, now elevated to international prominence as the judge who had dared to challenge royal prerogative, watched the preparations with satisfaction. His ruling had established principles that would endure long after the immediate crisis was resolved. The supremacy of law over tradition had been affirmed without destroying the institution of monarchy itself. Helena Morrison QC had become a constitutional celebrity, hailed as the lawyer who had proven that no institution was above the law. Her meticulous research had not only vindicated forgotten legal principles, but it also forced a productive evolution in constitutional practice. The ancient statutes she had discovered were now being reviewed across the Commonwealth to ensure similar oversights were corrected. On the morning of the ceremony, Westminster Abbey was filled with an extraordinary assembly of dignitaries. The Archbishop of Canterbury led a procession of senior clergy, while hereditary peers who had not participated in state occasions for decades took their appointed places. The ceremony represented a unique fusion of medieval tradition and modern constitutional practice. Queen Camilla entered the abbey with remarkable composure, understanding that this moment would define both her personal legacy and the future relationship between law and monarchy. She had spent months studying the historical significance of the ceremony and had embraced it as an opportunity to demonstrate the monarchy's respect for legal principle. The validation ceremony itself was both solemn and spectacular. Ancient Latin prayers that had not been heard in centuries echoed through the abbey, while representatives of the nobility formally acknowledged Queen Camilla's right to royal status. The fusion of medieval protocol with contemporary constitutional understanding created a uniquely powerful moment. Archbishop Theodore Whitfield delivered the formal validation, his words carrying the weight of both spiritual authority and legal requirement. By the grace of God and in accordance with the ancient laws of this realm, we do hereby acknowledge and validate the royal status and title of Queen Camilla, confirming her position within the constitutional framework of our monarchy. The moment the validation was complete, a transformation occurred throughout the constitutional system. The legal cloud that had hung over Queen Camilla's title was lifted, but more importantly, the precedent was established that even the most ancient laws retained their validity until formally repealed by Parliament. The international implications were immediate and positive. Commonwealth governments that had been grappling with constitutional uncertainty could now proceed with confidence, knowing that the British Crown's legal foundation had been strengthened rather than weakened by the crisis. In the months that followed, Parliament began a comprehensive review of ancient statutes to identify other dormant laws that might require attention. The process initiated by Helena Morrison's research had evolved into a broader constitutional housekeeping exercise that strengthened the entire legal system. Sir Edmund Worthington's judicial legacy was secure. His willingness to apply the law without fear or favor had proven that British constitutional principles remained robust enough to handle even the most challenging circumstances. The rule of law had been upheld without destroying the institutions it governed. The royal family emerged from the crisis with enhanced rather than diminished authority. Their willingness to submit to legal requirements had demonstrated that the monarchy's strength came not from being above the law, but from exemplifying respect for it. Public support for the institution had actually increased as a result of the constitutional crisis. Helena Morrison continued her legal practice with global recognition as a constitutional expert. Her discovery of the ancient statutes had not only changed British law, but had inspired similar research in other constitutional monarchies. Legal scholars worldwide now understood the importance of reviewing historical legislation for dormant but valid requirements. Years later, constitutional historians would mark Sir Edmund's ruling as a turning point in the relationship between law and tradition. The ancient statutes that had slumbered for centuries had awakened to serve a vital constitutional function, proving that even the oldest laws could adapt to serve contemporary needs. The ceremonial validation became an annual commemoration, with Queen Camilla participating in anniversary services that celebrated both royal tradition and constitutional principle. The crisis that had threatened to tear apart the monarchy had instead strengthened its legal foundation for future generations. The forgotten medieval statutes had served their purpose magnificently, not by destroying modern institutions, but by forcing them to evolve in ways that honored both historical precedent and contemporary values. The law had spoken with ancient authority but modern wisdom, creating a constitutional framework stronger than ever before. As Sir Edmund Worthington reflected on the case in his retirement, he understood that his decision had achieved something remarkable. The rule of law had been vindicated without constitutional chaos, Tradition had been honored without legal compromise, and the monarchy had emerged more legitimate than ever before. The ancient statutes had completed their long journey from medieval parchment to modern constitutional principle, proving that justice truly was timeless in its wisdom and eternal in its validity.